welcome, everybody. Welcome to the show. I am your host, Daniel, bringing you live court hearings with real judges and real court cases. I want to welcome all the new subscribers. Again, I'd like to welcome all the new subscribers to this channel. I want to iterate what the basic rules are of this channel before we go forward. And that is, you have respect for me, the host. You also have respect for each other in the chat. And no drama. If I see you acting in with bad behavior, I will lock you up. I will time you out the first time. The second time, I will time you out again with a warning. Third time, if you can't act straight, you're banned from the channel. There'll be no more drama on this channel. The only drama that's on this channel is what is being presented to you in the courts. So everybody is welcome here as long as you behave yourself like ladies and gentlemen. That's all I ask. So today is Judge Lynisse Bryant. She could be a pistol. I'll tell you what. But I am going to be here. I am watching the chat on my phone. I'm going to mute my mic. I'm going to get you guys started. I have to watch for ads. I have to skip ads or mute ads because music and ads, YouTube will strike the channel for copyright. So I'm here. I'm not trying to be antisocial. But I am here, I am watching. So let's get started. Share screen. Go back and make this bigger. I'm going to mute my mic, but I'm still here.
Davis, let's not ever do that again. Let's never do that again. Ma'am, let's not ever do that again, including right now. So here's the first thing. We are going to only unmute when asked to do so by the court. Number two, the baby can't come to court. The baby can't come to court. Baby can't come to court. So
Yes,
let me say this to you. Do not unmute yourself again and talk to me like I'm some random stranger on the street, because it will not work out good for you. Now, I don't know why you just chose to do that, but let me be clear. As I am indicating, we are in court. If you cannot attend court because there's too much going on at your house, I'm in the building facility. And then I need to contact, what's funny? It's funny. Unmute yourself. What's funny? Unmute yourself. What's funny? What's funny?
I wasn't laughing, I was doing like this.
No, you weren't.
I was, man.
In 56 years, I know what laughing looks like.
I wasn't laughing, man. Why would I be laughing? This is serious.
That's what I was thinking. In my mind, I was thinking, but what I do know is the difference between laughing and wiping your face. Ladies, please start your video. Miss Davis, you're going to have to probably put on a jacket, but hold on, please. Miss Wilson, you got that camera real up close to you, but if you're not properly attired for court, you need to put on a jacket too. All right, I'm going to put you in the waiting room. Your lawyer is not present yet. But while you're in the waiting room, please put on a jacket or change your top. This is, your lawyer is Mr. Wordling. Okay, so I'm going to put you back in the waiting room, Miss Wilson. Miss Davis, I'm going to put you in the breakout room, and a lawyer will be Ian to speak with you shortly, okay?
Okay, Your Honor.
Please remain in the breakout room until the lawyer comes in to talk with you.
Okay, and then I can go put the.
No, you can put the jacket on while you're waiting for them to come in.
Okay, this is a dress. It's a
Oh,
dress.
okay.
Yeah. Okay.
Oh, okay. All right, well, I'm ready on Miss Davis, who wanted to say whatever she was saying. So let me assist Miss Davis. So Miss Davis, let's not ever do that again. Let's never do that again. Ma'am, let's not ever do that again, including right now. So here's the first thing. We are going to only unmute when asked to do so by the court. Number two, the baby can't come to court. The baby can't come to court. Baby can't come to court. Number three, don't log in laying down, whether it's on a couch, in a chair, or whatever. So let me be clear. We're in court and we're going to present as though we are in court. Otherwise, you have to physically come to court. So if we can't sit up straight, as if we're standing up straight at that podium, then you can't attend court on Zoom. Then you have to come and stand at the podium. So
Yes,
ma'am,
let
let me say this to you. Do not unmute yourself again and talk to me like I'm some random stranger on the street, because it will not work out good for you. Now, I don't know why you just chose to do that, but let me be clear. As I am indicating, we are in court. If you cannot attend court because there's too much going on at your house, I'm in the building. I'm at 36th District Court. The building is open for all defendants who have matters pending before the court. So you're going to talk to me like I am the judge presiding, not like some person that you just met on the street or whomever. I don't know. But I'm giving you the instructions for how to attend court. They are the instructions for everyone who comes here. If you don't want to follow them, I don't know what to tell you. Now, I'm sure that in the beginning, I said, I need everyone to remain seated, stationary, in an upright position, and ready to attend court. This is case number 164609001. The people of the state of Michigan versus Crystal Davis. The defendant is charged with one count of malicious destruction of a building, one count of assault or assault and battery, and today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Crystal Davis. Ms. Davis, ma'am, please unmute and tell the judge your full name.
Good morning, Your Honor. Crystal Davis.
Today is the date set for a final pretrial conference. How are we proceeding?
Your Honor, on behalf of Ms. Davis, Your Honor, I'm not certain whether the complainant was required to be present today. If that is the case, we would move for dismissal for the complainant's failure to appear.
Ms. Ritter? You're muted, Ms. Ritter.
Sorry, Judge. My note says that there was an arraignment on the bench warrant on May 1st of this year. and a final pretrial conference was set for today, but I don't have any notes that the court required the complainant witness to be present, so I will defer to the court.
Not if it was an arraignment on the bench warrant, I didn't. So,
Okay,
I mean, again, I don't have my notes, but that would, generally, I would not have.
okay,
And it's at 9:04. That means that your client has failed to appear probably
That-
more than once, and then I set it for 9:04, which would have meant a high bond if she didn't appear today.
okay. So Judge, could we set a, I know it's a 2016 case. I don't know. I know that there were some efforts at an alternative dispute resolution when the case initially came about. We have an indication that that alternative dispute resolution, it has been complied with. And it was back in 2017, but Ms. Davis did not provide proof of that to the court. Could we have the matter reset for final pretrial conference to determine whether or not actually requiring the complainant's presence, and if the complainant is present, giving us an opportunity to still do the alternative dispute resolution?
So in 2017, that would have been under Giles or King. No,
Yes,
it could have been under Archer. Who, I don't know. Who was the judge back then?
I thought it was King.
That seems like it wasn't King.
But it may have been Judge Archer. I don't have the ROA in front of me right now.
Did she used to do alternative dispute?
Yes, Your Honor, the register of actions did reflect that should anger management be completed, that there would be a dismissal. And
Well, the anger management might not have worked. Because she's
Understood,
acting
Judge.
angry today.
So I have the certificate from 2017, but again,
Okay. I mean, I'll honor it, but I'm telling you, she acting angry today. So if Miss Ritter can look at her notes or whatever, and I mean, if that was the agreement back then, I suppose we'll honor it today, but okay, all I can say is I'll honor it today, but she might need to go to Mr. Rice's class. Is that certificate from Mr. Rice?
it's not, Your Honor.
I know it's not, because if it was, she probably wouldn't have been acting like this today. Okay, Miss Ritter, I want you to look at your notes. Ms. Stevenson says she has a copy of the certificate. The register reflects, that they were engaged in this alternative dispute resolution, and then she had a case dismissed. So if that's what the register reflects, or if that's what the notes reflect, maybe I also need to look at the actual file in the courtroom. Actually, Ms. Rutter, do you have the handwritten ROA where the judge writes on the file?
Give me one moment, let me check, Your Honor.
Yeah, check and see if you have that. Let me see what the judge wrote. If the judge wrote something, that's when we were definitely writing in the files back then. And then Ms. Ritter, you can also try to contact your witness. So I will adjourn the final pretrial conference, but if that was the agreement, like I said, I will honor it if she does have that proof. Let's set a final pretrial conference for that trial is really going off my docket. Let's do August 21st for the final pretrial at 9:04. And let's let me write this down. Proof of anger management and confirmation of agreement. Okay. So that's what I need that day. And I know we could, I was trying to see if I could do it sooner, but every day says no more, no more, no more. So I'm all booked up. All right. Well, unless we do it on one of those, I don't even see where we're doing any afternoons. No, because of that trial. Yeah, I'm booked up because of that trial, so that's it. Anything further then with respect to this?
Not from the people, Judge. Thank you.
Nothing on behalf of Ms. Davis. Thank you, Your Honor.
All right, then we're all set, Ms. Davis, until August 21st at 9:04. Have a great day. Stay safe. You're welcome.
Thank you, Your Honor.
You're welcome.
Your Honor.
He didn't. Mr. Hardwick, state your name.
Kevin Lamont Hardwick Jr.
All right. Today is the date Mr. Hardwick has been brought before the before the court on a tether violation. It says that he was found to be outside of his curfew as well as to have a low battery on the tether. Additionally, there's some information that indicates to the court that Mr. Hardwick is without a home, has some mental health issues, and may be on drugs. Court is inclined, based upon the report from the tether unit, to tether Mr. Hardwick to a drug rehab facility. Is there anything on behalf of the people or Mr. Hardwick with respect to the court's intention?
Nothing on behalf of the people, Judge.
No objection on behalf of Mr. Hardwick, Your Honor.
All right, then the court is going to tether Mr. Hardwick. The tether conditions remain. The only thing that's going to change is the location of his tether. He is not going to be tethered to the place that he was tethered to. And Mr. Hardwick can only be released to a rehab facility. And then I need to contact, what's funny? It's funny. Unmute yourself. What's funny? Unmute yourself. What's funny? Hold on, it won't let you. Hold on. What's funny?
I wasn't laughing, I was doing like this.
No, you weren't.
I was, man.
In 56 years, I know what laughing looks
I
like.
wasn't laughing, man. Why would I be laughing? This is serious.
That's what I was thinking. In my mind, I was thinking, but what I do know is the difference between laughing and wiping your face.
I wasn't laughing, man.
Yeah, okay. I didn't get all the way this far to not know the difference between laughing and wiping your face.
I wasn't laughing, man.
Okay.
I be having seizures.
Yeah, okay. Well, you wasn't having a seizure just now.
I know. I wasn't
Yeah, I
laughing.
know. So then it wasn't no reason to bring up seizures. Nobody's on here having seizures right now. Court is going to tether Mr. Hardwick to where was the place last when there was an issue with Judge Cobb's order, and they were saying they don't take women. I mean, they didn't take women, and Judge Cobb was trying to tether the person to Team Wellness, Team Jefferson. It was Team Wellness. So I'm going to tether Mr. Hardwick to Team Wellness. As a condition of his bond. When is his next court date? Ms. Rudder?
August 21st at 8:30.
All right. And then he'll be back before me for pre-trial August the 21st. Anything further?
Not from the people, Judge. Thank you.
Nothing on behalf of Mr. Hardwick. Thank you, Your Honor.
All right, Mr. Hardwick, you're all set. They're gonna get you a tether and get you a bed at Team Wellness.
Thank you, man.
You're welcome. Have a great day. Stay safe.
You too.
Thank you.
Yes, ma'am.
Start your video, Mr. Morris.
Okay.
Mr. Morris, take the do-rag off your head. And then I'm gonna say, and your braids all together. Why you got on? Y'all just be coming on do-rags for no reason.
No, because I was, yeah.
Cause aren't you trying to look good for a live Zoom as opposed? What you saving the hairstyle for? Don't answer. Just say, yeah, okay. Go to the breakout room, Mr. Morris. Go to the breakout room. Breakout room number 2. All right, I'm ready on Morris and then Patterson. Mr. Morris, turn your camera back on. All right. Morris and then Patterson. And Ms. Stevenson, you all are confused me with that HIDA designation, but I'll get to it in a minute. This is case number. This is the second person y'all letting come to court with a t-shirt on. Students are going to have to tell them to change their clothes. This is case number here it is. Case number 145509101. The people of the state of Michigan versus Davon Lawrence Morris. Defendant is charged with 1 count of driving while license suspended, revoked, denied. Today is the date set for an arraignment on a bench warrant. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the
Ronnie Melka appearing on the behalf of the defendant, Devon Morris, who consents to my appearance. Is that correct, Mr. Morris?
Yes, ma'am.
Can you please state your name for the record?
Davon Morris, Deontay Morris.
What does that mean? What does that mean? He said Davon Morris, Deontay Morris. What does that mean?
No, I said Davon Lawrence, Deontay Morris.
Oh, okay. Thank you. Because I'm saying you had 2 names. Okay, so your name is Davon Lawrence Deontay Morris.
Yes, ma'am.
Okay, thank you. Today is the day set for an arraignment on a bench warrant. What did Mr. Morris capious from, please?
Mr. Morris capious on May 12th, 2017.
From?
From missing a court date.
Counsel. No. Question is, what did he capious from? I know he capious from a court date. Was it a pretrial? Was it an arraignment?
Oh, it was a
final
pretrial.
Okay. Well, we'll continue. Now, here's the thing. Mr. Morris, in 2017, I think I was doing, I don't know what docket I was on in 2017. I don't know. I know I wasn't on this one. Now, let me tell you something about these misdemeanors for my docket. Setting up a meeting with the chief of police. I'm asking the chief of police for a warrant fugitive arrest team for the misdemeanor docket. We're not going to wait for you for how many years that's been. We're not going to wait for you this time. You need to come to court, okay?
Okay.
So I don't want to keep doing these old cases, okay? Because people get new cases. My docket is too full, and then the people come on here fussing at me because I can't give them a court date in 2 weeks and 3 weeks. Okay, so I'm going to give you this court date. I want you to show up and write down the right date.
Okay.
Okay. When is your court date?
August 24th at 8:35.
Okay.
a.m.
All right, Mr. Morris. He like, I got it, Judge. And then don't come on here with that do-rag on, because which one you think look better, the do-rag or your hair?
My hair. I'm sorry.
I know. Exactly. Okay. All right. Anything further with respect to Mr. Morris?
Nothing further.
Miss Ritter?
I'm sorry, Judge, nothing from the people.
Okay. Miss, I'm here.
Fighting over this case. I didn't just check boxes on a paper.
If you rewind the video, you said you were going to send it to me.
Ooh.
Okay.
Okay.
Can we go back to breakout, please, Judge?
You might need
Please.
to, because Miss
All
Williams
right.
get ready to get this probation revoked. Now,
Okay. If we
go
could
back
just
on no video, because
to
I've been
breakout.
doing this job for 15 years. And what I know without ever looking on a video is that out of my mouth, I said the terms and conditions of probation. And then at the end of that, I said, I will mail you a copy. But you need to go back and think, because first of all, she's coming in person. Because I'm sick of this right here. This whole look. Brianna Williams. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for review. Ms. Stevenson.
Janice Stevenson on behalf of Brianna Williams. Ms. Williams, ma'am, please unmute and tell the judge your full name.
Brianna Yvette Williams.
Thank you, ma'am. Today is the date set for review. And I didn't request Ms. Williams's update from probation. Her probation officer is off on leave, so I don't have an update from her for her, but just looking at the register of action, Ms. Williams was placed on probation by this court in March. So this is her first review. It was a 12-month delayed sentence, so she's not eligible for discharge yet. I did order her to do anger management. It doesn't say how many in the register. It says mental health counseling, urinalysis. Oh, I didn't sign a delayed sentence order. That's not, so apparently we didn't do an order back in March. And then I'm looking at the register and it says, in my absence, Judge Evans signed an order. That's probably why it doesn't say how many anger management classes.
Your Honor, may I?
You may.
I remember that day. I could not locate the original order. So when Judge Evans stood in, she signed another order, but then I found the one that you had signed on March the 10th, and I also forwarded that over to probation.
Okay, tell them to disregard that last order, because that, if it's different from mine, disregard that, disregard it.
Okay.
So that's, yeah, we're gonna rescind that order from Judge Evans. We're gonna rescind that order. All right. Okay, so Ms. Stevenson, what does Ms. Williams think she's done already?
She has been in touch with Ms. O'Driscoll and has been waiting to hear what her exact conditions of probation are.
Nah, that's okay. Now y'all know that ain't the truth. Okay.
So, I mean, I'm going to say this on behalf of Ms. Williams, Your Honor. She has, she already has all of Ms. O'Driscoll's contact information. Most of my clients, when they get to this point, they don't have all that. And I do think she's kind of been, you know, in a place where she's waiting. If we could get a copy of the court's order emailed to, if it could be emailed to me, and then I'll forward it to Ms. Williams. I gave her Eve's contact information today. She didn't know how many anger management classes she was supposed to take, so I encouraged her to go ahead and sign up for 12.
You mean she didn't remember? Because don't say I didn't say it on the day of her sentencing. So let's.
Oh, yes.
She didn't remember.
It was supposed to be sent over to me. That's what it was supposed to be sent over.
Ms. Williams.
Ms. Williams, like I said what I said, and I'm saying it again. I didn't just check no boxes on a paper and say you'll get you'll get this paper. I didn't just check boxes on a paper.
If you rewind the video, you said you were going to send it to me.
Okay.
Okay.
Can we go back to breakout, please, Judge?
You might
please.
need to, because Ms. Williams get ready to get this probation revoked.
Okay.
Now, go back on no video, because I've been doing this job for 15 years. And what I know without ever looking on a video is that out of my mouth, I said the terms and conditions of probation. And then at the end of that, I said, I will mail you a copy. But you need to go back and think, because first of all, she's coming in person, because I'm sick of this right here. This whole little attitude she has.
We're right
this
back.
Whole thing right here. This whole attitude right here.
Okay. If we could go back to breakout right now, please, Your Honor, I would really
she getting ready to
appreciate
go
it.
to jail. Go to breakout, because she getting ready to go to jail. Let me close these rooms so you can talk to her. And let me say this, it's nothing funny going on in my courtroom right now. And there's only one person in my courtroom right now, which is probably why you here on this assault and battery case that's in danger. Now, I don't know who you think I am or where you think you are, but let me be clear about something. My name is Judge Lynisse Bryant, and I am presiding over this case. You're going to be respectful. You're not going to keep interrupting the court. You're not going to keep turning your head around and laughing, because I know how to do my job. I do it very well. In fact, I do it extremely well.
If we could go right away, Judge.
I know, because you scared. You like, Judge.
I am.
Okay. All right. Then I'm going to stop talking. I'm going to stop talking. Miss Stevenson, I'm going to stop talking. And then I'm going to do this right here.
Appreciate
and I'll
it,
start
Judge.
bringing. So are we ready to go back on the record with Miss Williams?
We are, and I have an update of information for the court.
Okay, and I know you might tell me some stuff she's going through, but you're not going to come on here and be disrespectful to me. Miss Stevenson, go ahead.
Thank you very much, Your Honor. So, Ms. Williams, this is our office's first interaction today with Ms. Williams, and I did have an opportunity to observe what was going on with Sister Counsel. And because, there are probably some resources available here at the court that Sister Counsel was not aware of. I think this case, having watched Ms. Williams in her prior hearings, having talked with her today, having watched the dramatic shift, Your Honor, in her demeanor from when she and I were in breakout till she came out before the court. She does have a mental health diagnosis. I don't know if a PSI was ever done. And I know probably maybe because at sentencing, it looks like this one slipped under the radar because there was a substitute
Her attorney
in.
was Miss Marable, and I
right.
Mm-hmm.
So she had retained counsel. We had a substitute judge at the sentencing, I think. And so I really would like Ms. Williams to be able to talk with someone from the specialty court. I don't know that we would be able to do that today. And if we can, that would be great. But I do think this would be a better fit if she's eligible. I forgot how Mr. Yancey called it. I like the word.
I did too, and I tried to say it yesterday, but I couldn't remember it.
Right. Behavioral special or something like that. I don't know.
Yes.
But I think if she's eligible, I think this is a better fit for the specialty court.
Well, let's see if we can get them on.
Okay.
Time. I need that much time. This is the court's docket. I need that much time. And the people are going to get 2 months to get the discovery to you. Okay. And then in the future, counsel, when I answer a question, the first time I answered the question. You keep asking me again.
I'm sorry, Your Honor. I don't mean to be disrespectful to the court. I've never been in front of this court before, so I apologize if I've offended the court in any way.
You didn't offend me. You didn't offend me. I'm bringing it to your attention. You didn't offend me. I said no, you couldn't come early. Then you said, "Are you sure?" That's basically what you said. Are you sure? I'm not offended. I'm just letting you know.
Okay, thank you, Your Honor.
Okay, all right.
Thurman Worlagon Jr.
Thank you. Today is the day set for pretrial conference. How are we proceeding?
Your Honor, can I inquire if Ms. Ritter is going to be handling this case next time, because I want to be able to communicate with her outside of court, give her additional information about my client, and also there's some additional discovery that I have not been tendered that I need to get.
She's my courtroom prosecutor. I'm not sure what you mean by is she going to be handling it next time? She's the prosecutor.
What I'm asking is, I want to schedule for another pretrial, but I want to be able to contact her outside court, give her additional information about my client and about the situation, and be able to get the discovery that I need
Okay, I mean, I think I answered your question, counsel. She's my courtroom prosecutor.
Okay. All right, Your Honor, what I'm asking for today is an adjournment to this is the first pretrial. I'd like another pretrial, and I want to communicate with the prosecutor in the meantime.
The court will continue a not guilty plea on behalf of Mr. Ligon. Set the matter for final pretrial conference. Court will set a final pretrial conference. Oh, Madam Clerk, I don't have it looks like I left my calendar on my desk, so I'm gonna need you to maybe pull up a little bit more, but a court is gonna set a final pretrial conference for Friday, October the 13th at 9:00 a.m. Discovery should be submitted by September the 13th. Bond will continue with no contact with the complaining witness and anything further.
Yeah, Your Honor, if we do have a resolution prior to October 13th, would we be able to get on your docket?
No, if there's a resolution, it'll be resolved on October 13th.
Okay, and there is no date that's sooner. I don't know that we need that much.
I said, no, I need that much time. I need that much time. This is the court's docket. I need that much time. And the people are going to get 2 months to get the discovery to you. And then my docket says October the 13th.
Okay, thank you, Your Honor.
Okay, and then in the future, counsel, when I answer a question, the first time, I answered the question. You keep asking me again.
As you can see,
I'm sorry, Your Honor, I don't mean to be disrespectful to the court. I've never been in front of this court before, so I apologize if I've offended the court in any way.
You didn't offend me. You didn't offend me. I'm bringing it to your attention. You didn't offend me. I said, no, you couldn't come early. Then you said, are you sure? That's basically what you said. Are you sure? I'm not offended. I'm just letting you know.
Okay, thank you, Your Honor.
Okay. All right. Anything further for the record?
Not from the people, Judge. Thank you.
Nothing further, Your Honor.
Okay, then we're all set until October 13th at 9:00 a.m. Have a great day and stay safe.
Thank you, Your Honor. You too.
You're welcome. Thank you. All right.
I don't know how this stuff works. I'm new to this, so I'm 50.
Okay, well, sir, hold on now. Are you okay? And Mr. McCreary, your name?
Ernell Michael McCreary, ill, all lowercase, not the all caps corporation.
Nobody writes the name in all caps. All right. So today is the date set for a pretrial conference. And Mr. McCreary, I understand that you are representing yourself. So how do you wish to proceed, sir?
First and foremost, if I may address the court and ask the court a few questions, with all due respect, may I speak?
I don't answer questions to counsel. I don't answer questions. That's not my role.
Well, I just wanted to say, you know, when I first came onto the Zoom, I felt that this court was disrespectful and restrained my First Amendment right to allocate myself here in this courtroom. And I'm not saying this as a personal attack, but that's just how I felt.
Okay, Mr. McCreary, all due respect, I'm not interested in your feelings, sir. I'm here to conduct court. So let's conduct court. How do you wish to proceed as it relates to your court matter?
I would like to challenge the plenary jurisdiction of this court as outlined by state Supreme Court.
Today is not the date for a motion. If you would like to file a motion with the court, I can give you a motion hearing date. But otherwise, I want to know as it relates to this pretrial conference where you've indicated that you want to represent yourself. It is your responsibility to understand the rules of court and how to represent yourself. Today is only the date set for a pretrial conference. As it relates to the pretrial conference, how do you wish to proceed?
Well, if I may speak without being restrained again by the court. You're
going to be restrained every time you go off course. So understand every time you go off course, you're going to be restrained. You're going to be restrained in the same way that I would restrain any other person, any other lawyer, any other person
who's not coming to court and addressing the court in the way that you're supposed to address the court for the pre-trial conference. So I'm asking you, Mr. McCrary, as it relates to the pre-trial conference, how do you wish to proceed?
I would like to ask that this court remove itself under MCR 2.003 for judicial bias. And once
Okay,
this
motion is denied. Anything further?
Well, I would like to have it sent to the chief judge as required by the rule.
Mr. Flanagan, please call the chief judge and let him know that there's a request for recusal by Mr. McCrary and ask him how does he wish to proceed with the hearing for Mr. McCrary.
Yes, Your Honor.
Violation in code of judicial conduct, judge. And I
I've
haven't
been
been
doing this for 16 years. I know what I'm supposed to do. So, Mr. McCrary, I'm addressing Mr. McCrary. I'm addressing your request on the recusal. So everything else, we're going to stop talking until I hear from the chief judge as to whether he wants you to come now or if he's going to give you a date.
Okay.
Thank you.
The rule matters.
Okay, thank you, Mr. McCrary. Thank you, Mr. McCrary.
Yes, ma'am.
Your Honor,
Yes, sir.
they indicated that he would need to file a motion for recusal before you. And if you deny that, it then goes to the chief judge.
He already did. I accepted his oral motion. I denied it. So tell them it's denied. I'm not requiring him to file a written motion. The court rules don't require a written motion. He requested thank you for affirmation, but I don't need it. He requested the recusal and I denied it. So ask them how do they want to proceed. I can sign an order of denial if they want me to just do an order of denial, but I've denied the recusal request.
Yes, Your Honor, the order of denial needs to be signed.
And then they're going to give him a date. In past times, some chief judges take the matter up immediately. So I just want to know, do they want me to give them a date?
Okay. Your Honor, no date. They said just sign the order and we'll bring it up. They'll contact them for a date.
All right. So, Mr. McCrary, please contact my courtroom. Make sure that my clerk has your current contact information. And apparently the chief judge's office is going to contact you with respect to your request for recusal. I will sign an order denying your request and then forward that to the chief. Okay.
Who do my call? The clerk? What is
sir, if you just, I promise you, I've been on the bench for 16 years, and I promise you, if you just let me talk, everything you want to know will be revealed. I promise you. Okay. So as I was saying, you're going to contact my courtroom and you will speak with the clerk. Make sure the clerk has your current contact information so that the chief judge's office can contact you with respect to your hearing on my denial of your request for recusal. Anything further with respect to this matter? Please don't unmute. Who is saying hello?
Oh, can I speak or no?
Oh, well, what else is there, Mr. McCrary?
I would like to just say this, Judge. I have nothing personal with you. It's just that
Mr. McCrary, I don't take things personally. Ms. McCrary, let me say something to you. So since we're talking, let's talk. If you would let the matter proceed, this is an old case. So let me just say that this case is from 2002. And maybe if you had watched my courtroom on YouTube, maybe you would have seen how these old cases from 2002 are handled. And then we could have came on here and it would have been handled the same way. However, we're going to proceed in the manner that you wish to proceed. And so I'm not going to keep going on because you've asked me to recuse myself. I have denied the recusal. You have requested an appeal. I have granted that appeal, and that concludes the matter. Is there anything further that is needed for the record? Because you don't have to tell me it's not personal. I could care less about, I don't take things personal. Why would I take things personal?
I take it personally because as a black man, a 50-year-old man,
This has nothing to do with you being a 50-year-old black man. This has anything to do with you being a defendant in this courtroom. Is there any legal thing for the record? Is there any legal matter for the record?
The prosecutor's office has committed a felony against me.
Okay, well, you can address that with whoever. You can address that with the appropriate parties, but I could say I'm qualified to teach, but if I don't have a teacher certificate, then I'm not allowed to teach. So let's stop having conversation, sir. This is not a conversation. Let's stop having conversation. Mr. Martin, you're dark. And then I don't know what you just put in your mouth, but please understand that we're in court. I need you to please be seated, stationary, in a place where I can see you and ready to attend court.
I was attacked by 3 people
okay, so sir, let me interrupt you. Miss Ritter, you just gonna mute the person?
No, Judge, and if he has any questions, he can reach out to the prosecutor's office and we'll answer those additional questions.
Okay, well, let me okay, Mr. Murad, stop muting my people.
So the note that I have is for the people to speak with the complainant and to determine whether she wishes to proceed, that she is not required to appear today.
Ms. Stevenson, those are your notes, how you wrote it down. I can't tell you, but what I do know is there's no way on this side of whatever y'all believe in. And then I said they're a minor. Well, I'm not asking their wishes. I'm telling them they better respond to the people's subpoena or they might find themselves arrested. They're a minor. And then Miss Ritter, you had oh no, I'm not. Some complaining witnesses look like they left.
Excuse me, Honor.
Yes.
They're gonna come in.
Okay. So you had a complaining witness on Mayberry.
Yes. He's still in the breakout room, Judge. He's actually on the telephone, so I told him to stay put in that breakout room.
Oh. Well, it's time to release him.
Okay. I'll try to move.
When Miss Stevenson or Miss okay, yeah, Miss Shive is here, so all right. So with respect to the person on the telephone that's identified as Steve Williams, good morning.
Good morning.
All right, so Mr. Williams, I'm sure you were perhaps advised that in the future, you have to, if you're going to attend court, you need to attend by video conference. Otherwise, your appearance, we have no way of knowing who's on the telephone.
I understand.
All right. Or you can come in person if you want to, but you are the complaining witness on Mayberry, correct?
Right, on the Mayberry family.
And the defendant.
Yeah, I'm sorry.
Yes, please. The defendant has failed to appear. All right, the court is adjourning the matter to July 10th at 8:35.
Okay. Yeah, may I ask you a question?
You perhaps, but I probably won't be able to answer it. What is your question?
I was attacked by 3 people and
okay, so sir, let me interrupt you. Miss Ritter, you just gonna mute the person?
No, Judge. So I had a conversation with Mr. Williams and I explained to him the procedures of today's hearings. And if he has any questions, he can reach out to the prosecutor's office and we'll answer those additional questions.
Okay, well, let me, okay, Mr. Murad, stop muting my people. Sir, that is a question that I would not be able to answer. That's an issue between you and the prosecutor's office. If you have any questions about who has been charged in the case, that's a question for the prosecutor's office. That has nothing to do with me. And so the case has been adjourned to July the 10th at 8:35. Have a great day and stay safe. All right.
Mr. Interpreter, if you could please start your video. All right, thank you. And I'm now ready on Bamaka. Mr. Interpreter, please state your name for the record.
Ricardo Cáceres, C-A-C-E-R-E-S.
And please raise your right hand for me. And are you a certified Spanish interpreter?
I'm qualified, Your Honor.
I said, are you a certified Spanish interpreter?
No, I am not. I qualify.
Who sent you here? The court services sent you?
Yes, the court sent me the order.
Oh, can you call Madam Clerk? Can you call court services and ask them when did they start sending uncertified interpreters? How am I supposed to proceed on a court proceeding with an interpreter that's not certified?
One moment, Your Honor.
Thank you. Sir, you can put your hand down.
Just for the record, Your Honor, I am qualified.
No, it's no record, sir, unless I say it's a record. I don't know what qualified means. What I'm telling you is that the law requires that I have a certified interpreter for the interpreting services. I don't know if you qualified or not, but I want to know if you're certified by the court. That's all I need to know. So it's no record unless I make a record. It's no record. It's a question on the floor to the court services. We have to have certified interpreters, and we have several that come to court. I don't know what it means to be qualified. I could say I'm qualified to teach, but if I don't have a teacher certificate, then I'm not allowed to teach. So let's stop having conversation, sir. It's not a conversation. Let's stop having conversation. Mr. Martin, you're dark. And then I don't know what you just put in your mouth, but please understand that we're in court. I need you to please be seated, stationary, in a place where I can see you and ready to attend court. Thank you. Madam Clerk, anything?
Oh, yes, Your Honor. I spoke with interpreting services. They're going to get you a certified interpreter, and they're going to check into the qualified interpreter that was sent.
Oh, okay. Okay. So what? Okay. Okay, let me call somebody okay, thank you. Counsel, have a seat for a moment.
Thank you, Your Honor.
You're welcome. All right, well, I'm gonna pass the case for a minute because I had to call, I did call court administration, so she's gonna find out if this is okay, because I don't necessarily want to have to wait long for another interpreter, so she's gonna find out if this is okay for me to proceed, so just give me a moment. Okay, let's do Martin and then Brookins. Oh wait, here's the court administration. Okay, hold on. All right, so I have been educated as to what the difference is between the qualified and certified interpreter is, and and that they are allowed for a period of time to interpret for the court. So I'm satisfied. And so let Ms. Villarreal know that she can, her services are not required. And then I am ready then on Bamaka. Counsel, you all can step back up to the podium. Good morning, Ms. Villarreal.
Good morning, Your Honor. How are you today?
I'm doing wonderful. Thank you. How are you?
Well, thank you.
Ms. Villarreal, thank you for showing up at such a short notice, but We did work out the issue that I had, and so now I don't need your services.
Oh, okay, that's fine, Your Honor.
But thank you as always. It's always a pleasure to have you, and thank you for being available and coming on a short notice. I appreciate it.
You're most welcome, Your Honor. You have a good day.
All right, you as well. Thank you.
Thank you.
All right. Okay, so now counsel, I mean not counsel, Mr. Interpreter, now you can raise your right hand. Do you swear or affirm that you will translate from English into Spanish, anything I say, counsel says, or the clerk says, and from Spanish into English, anything Mr. Bamica says to the best of your ability?
I do.
All right, thank you. Okay, and so this is case number 224570401, the people of the state of Michigan versus Julio Victor Bamica.
Este es el caso 2245700401, el estado de Michigan contra el señor Julio Bamica.
All right.
May I leave, Your Honor?
You may, yes.
Thank you very much.
You're welcome. All right, I'm ready on Boykins. Looks like the witness is back. Or Brookins. I said Boykins. I meant Brookins. Okay, Mr. Brookins, your device is moving around a lot.
I apologize. I just got out of surgery, Your Honor.
Okay. Ms. Ritter, oh, here we go. For a final pretrial conference, Ms. Stevenson?
So thank you, Your Honor. It is my understanding that by today's date, the people were to determine the cooperation of the now 16-year-old complaining witness after getting some direction from the court. And I'm not sure where we are with that.
I apologize, Ms. Stevenson. Say that again.
I want to pull my exact notes, Judge.
Was this, you're saying this was something I was supposed to do?
No, Your Honor, at the direction of the court, it is my understanding that the people were to make contact with the complaining witness, who is now 16 years old, Your Honor, and determine whether she's available to be in court or whether they would be able to proceed.
Ms. Ritter, you're shaking your head.
So, Judge, my notes indicate that the court set this for jury trial on July 5th of this year at 10:30, Your Honor. And the court indicated that the people must inform the witness that they have to appear because they are underage, they are still a minor, and that they have to appear for the trial date.
That sounds like what I said.
So the note that I have is for the people to speak with the complainant and to determine whether she wishes to proceed, that she is not required to appear today, but that the people were to have a conversation with the complainant.
Ms. Stevenson, those are your notes, how you wrote it down. I can't tell you, but what I do know is there's no way on this side of whatever y'all believe in, heaven, purgatory, hell, whatever it is, that I'm going to let a minor tell me that they don't want to proceed. It's no way.
Okay.
So it's no way. So I don't care if they want to proceed or not. They're going to come to court and testify and answer the people's questions. So that's how that works. Now, I think I told Ms. Ritter's notes sound more like what I said, because maybe somebody told me that the complainant did not want to proceed. I don't know if it was this case, but I do remember a case where somebody said the complainant didn't want to proceed. And then I said, they're a minor. Well, I'm not asking their wishes. I'm telling them they better respond to the people's subpoena or they might find themselves arrested. They're a minor, and I'm never going to let a minor tell me that they don't want to proceed. It'll never happen. So they can come and answer the people's questions, and then a jury can decide based upon their answers to the people's questions whether or not the people have been able to meet their burden. That's all I'm doing.
Okay.
So
we have trial set for July 3rd.
No, we don't. It's set for July 5th. We changed dates with Judge Garrett so we wouldn't have to break. In the proceedings. So we have trial for July 5th. The trial is July 5th. This is the case where I called to make sure that Judge Garrett didn't have a trial scheduled on July 5th. And then Mr. Navin switched my jurors to July 5th so that we wouldn't have to come on July 3rd and then not come on July 4th and then come on July 5th. So we're starting trial on July 5th.
Okay. Okay. So we continue the plea of not guilty at this point, Your Honor.
I know I sound like you're getting ready to ask me for something that I don't want to give you.
I know, of course I'm going to do that. So, well, I am going to ask, for final pretrial conference, Your Honor, prior to the July 5th trial date at Well, I am going to ask for final pretrial conference, Your Honor, sometime that week before the trial date.
I don't think I have space, but we'll see. Oh, I'm coming in person on June 28th to see Miss Williams.
Right.
Miss Rudder, how many do I have on June 28th?
June 28th.
I sure can fill up a week quick though, because I wasn't even putting stuff on that day on that week, and then when I decided not to go to the thing, I just filled the week up. How many?
24, Your Honor.
What about the 27th?
$17.
And what about the 26th?
$11.
26th, final pretrial conference. Not guilty, continue. June 26th at 9:10. Final pretrial conference. Anything further?
No, thank you, Judge.
No, not at this time. Thank you very much, Your Honor.
Jurisdictions that only had 3 cases on the docket. But when you come into a jurisdiction that's working every day, all day, then, I mean, this is what we're going to do.
All right. Oh, blessed assurance, they got the 2 defendants in here together. What's this about? What kind of foolishness is this? Can I get the deputy, please? This is some foolishness. Let's not do that. This is some foolishness. This is some foolishness. Deputy, this is some foolishness. Can these 2 why are these 2 defendants both on my screen and that other defendant walking around and behind this defendant. I need him to go have a seat somewhere until it's time for his case. That's a mess. And then she cut off her tether. Mr. Moran.
Your Honor, I don't believe she cut off her tether.
Well, what it say? Why she didn't cut it off? Tell me.
Judge, I thought that this was a violation based on the fact that Ms. Brown did not tether to an appropriate address.
The device was recovered and the subject did cut it off. What are you saying?
Judge, I believe I need to talk to Ms. Plawecki.
Oh, because she told you that she just wasn't at the right place? Okay, don't answer, because that'll be about, okay, so she can move out the chair. The report says she cut off the tether. They found it on the street.
Mr. Sanders, unmute yourself.
Yes, ma'am.
You said I was tired of waiting for the court, so I'm just gonna leave?
No, I didn't. No, I did not say that. My phone had died. I told her I had texted the lawyer and told the lawyer that I've been on the phone for a whole hour and the phone was dying.
Yeah, a whole hour. Yeah, that's something. That's something. We've been on there for a whole 3 hours working. Okay. Next time you have to come to court, charge up your phone the night before so that you won't feel like you've been on something for a whole hour and we should have got to you in an hour. Okay. Because next time I'm not going to tell her to call you. Next time you just going to have a warrant out for your arrest.
But if I had my phone on the charger for a whole hour, well, my phone.
I'm not going to argue with you, Mr. Sanders. What I'm not going to do is argue with you. So here's where we are. The court building is open. Well, Ms. Stevenson, I feel disrespected. I'm going to do like the young man earlier. I feel disrespected. And so since I feel disrespected and I'm the judge, I'm wondering if I feel disrespected and I decide I'm not going to continue with the cases, what does that mean for the defendant? Because let me tell you who doesn't have a criminal case on the docket today. Me. Let me tell you who doesn't have an attitude today. Me. Let me tell you who is in the proper place that I'm supposed to be. Me. Let me tell you who was nice enough to say, Ms. Stevenson, your client is no longer there. Maybe you should call them. Me. Because did I have to do that? No. So if you have an attitude, Mr. Sanders, because you have 3 cases on the docket today, if you have an attitude and you don't want to come to court, just go away. We are not interested in that negative energy. We're not interested in somebody with an attitude because they have cases on the docket. We're not interested in a person who thinks that they should come to court and then all the other people who came before them, who got here before them, their cases should be heard because we don't want to make that person wait for an hour. So if we're ready to proceed in a respectful manner, without an attitude, we can proceed. Otherwise, I'm not interested in doing cases anymore for people with attitudes as if I've done them some harm. I'm not interested. So Ms. Stevenson, are we going to be proceeding? Because it's a lot that I could say right now about how he's sitting for court, how his place is dark, how we can barely see his face. I mean, it's a lot that I could say, but I'm just ready to proceed. So Ms. Stevenson, are we going to be able to proceed in a respectful manner or are we logging off?
I certainly believe we can proceed in a respectful manner, Your Honor. If the court would like, I could take a very brief breakout with Mr. Sanders, or we could.
He's gonna be rude to you in a breakout room too, and say he been waiting an hour. Like people, okay, this 36th district court. Now, if he only want to wait 5 minutes, then he should get accused of crimes in jurisdictions that only had 3 cases on the docket. But when you come into a jurisdiction that's working every day, all day, then I mean, this is what we're going to do. And we're going to get to the people in as quick
manner as we can. After the lawyer had to speak to 20 people in the breakout room. So maybe Mr. Sanders want to hire his own lawyer, so that lawyer only has to speak to him, and then that lawyer will be ready to proceed immediately. These are case numbers. 2-2 versus Jawan Sanders. In each matter, the defendant is charged with 1 count of assault or assault and battery. I forgot to share my screen. As to each matter, how are we proceeding?
Thank you, Your Honor. On behalf of Mr. Sanders, we would thank the court for hearing the matter. We would move for dismissal for the complainant's failure to appear in each of the matters, Your Honor.
Ms. Ritter?
Judge, these cases are listed as a first-time pretrial conference in this court, so I'm going to respectfully ask the court to adjourn the pretrial conferences to give the people an opportunity to reach out to each of the complainant witnesses. It looks like each of these incidents took place in the Wayne County Jail, Your Honor. So the people would like to locate the complainant witnesses and see how we will move forward in each matter.
The court is going to deny defense counsel's motion for dismissal. This being the first scheduling of the pretrial conferences, I will grant the people's request for a one-time adjournment, giving them an opportunity to notify the witnesses of the obligation that they appear before the court. The complaining witnesses are required to appear. Failure of the complaining witnesses to appear will most likely result in the matters being dismissed unless the people have a valid explanation as to why the complaining witnesses could not appear or should not be required to appear. Bond will continue with no contact with the complaining witnesses. Anything further for the record?
No, thank you, Lord.
Nothing further at this time. Thank you very much, Your Honor.
All right, then we are all set until August the 1st at 8:36. Sir, have a great day and stay safe. Can the jail unmute for me and start the video? All right. Oh, blessed assurance, they got the 2 defendants in here together. What's this about? What kind of foolishness is this? Can I get the deputy, please? This is some foolishness. Now, let's not do that. This is some foolishness. This is some foolishness. Deputy, this is some foolishness. Can these 2 defendants, why are these 2 defendants both on my screen and that other defendant walking around and behind this defendant? I need him to go have a seat somewhere until it's time for his case. That's a mess. And then my other question is, Deputy, I have an attorney here for Xavier Evans that's supposed to be on in the Wayne County Jail. Do you don't have Evans?
I should be zooming in from Division 2, ma'am.
Oh, Division 2. Okay. All right.
665 on behalf of Miss Nicole Brown, Judge, who's in the Wayne County Jail on Zoom. Miss Brown, unmute your device and state your full name for the record. Your Honor, there's also an alias here. Miss Brown's real name is Miss Destiny Plawecki. I believe it may appear on the ROA as Nicole Brown.
Okay. Well, she's gonna be Nicole Brown today.
Right.
Unmute and state your name. Unmute.
I'm Destiny Nicole Plawecki.
And are you known as also Nicole Brown?
Yes.
All right. Ms. Ritter, let me know if you have the report.
I have the report now, Judge. Thank you.
Welcome. She cut off her tether. Mr. Murad.
Your Honor, I don't believe she cut off her tether.
Well, what did it say? Why she didn't cut it off? Tell me.
Judge, I thought that this was a violation based on the fact that Ms. Brown did not tether to an appropriate address.
Okay, on July the 12th, 17:10 hours, I was monitoring the OmniLink software and there was a strap tamper alert for the above subject. Officers Julian LeBron and I made the last known trace of the device at the corner of Cecil and Serena in the city of Detroit. The device was recovered and the subject did cut it off. What are you saying?
Judge, I believe I need to talk to Ms. Plawecki.
Oh, because she told you that she just wasn't at the right place? Okay, don't answer because that'll be about, okay, so she can move out the chair. The report says she cut off the tether. They found it on the street.
Judge, I definitely need to talk to her one more time if that could be possible, so I can.
Okay, well then you could talk to her after we go to the next case.
Yes, Judge.
Ma'am, step back and let Mr. Britt come to the screen. Mr. Murad, now that you have had an opportunity to get the truth of the matter.
Your Honors, I apologize. There may have been a miscommunication, but that's all been rectified with Ms. Brown and I. Judge, she does stand in violation of the tether. There's no good reason that I can tender to this court why it happened, but it did. I can tell the court why it happened if the court would like to know. However, what I'm going to ask the court to do, Judge, and I think the court will figure out why it happened when it hears my request, I'm going to ask that the tether remain on, and instead of confining her to a home, that she be confined to Positive Images, which is a rehabilitation facility here in the city of Detroit. There are some struggles with sobriety in this particular matter, and I think that Ms. Brown would tremendously benefit if the court would consider the sanction here to be a confinement tether to that rehab facility.
Yeah, but she's also going to pay for that tether. She's going to pay for the tether that she destroyed.
So, Ms. Brown, at this time, I would not recommend making any statements.
The court will continue the bond conditions and change the location of the tether. There was a time when I would have at least considered removing the house arrest portion, but this is not one of those times. Where are you asking me to tether her to?
It's Positive Images, Your Honor. It's a rehab located at 700 East Grand Boulevard.
Well, and here's the thing. So we know if Positive Images doesn't have space for Ms. Brown, that means she's not going to be tethered.
I understand, Your Honor.
Space.
I understand that, Judge.
All right. Well, maybe perhaps I will say Positive Images or Naomi's Nest. Whichever one has a bed. And it is it remains a restricted house arrest tether. Anything further?
No, thank you.
All right, then we're all set with Ms. Brown. All right, Ms. Brown, you're all set. I'm ready on, well, let me bring in Gutierrez and see if they're. Jail, where all phone calls are recorded on a recorded. I don't need any affirmation. I don't need any thumbs up, thumbs down. I don't need anything.
Mr. Henderson, just listen, please.
Please don't be silly enough to think that it's not easy to find out who's contacted who. With the flick of a pen, we can get the record. Just with the signing of a warrant, with the signing of a subpoena, we can get the records. So stop acting like we can't tell who contacted who. Stop acting like if somebody, a third party contacting another person, we can't get the record and say, you called this person on this day, this person called her on this day. Stop acting like kids on here. today is a day set for a pretrial conference. Is this matter properly before this court?
So, Your Honor, I had an opportunity to speak to Mr. Henderson. From my understanding of the conversation that we had, I believe that this would be more proper for the DV docket.
All right, Mr. Flanagan, can you call next door and ask the clerk what is their pleasure? Do they want me to send the individuals there now or just give another date?
Okay.
Probably another date, because
Could you go make me a cup of coffee, please?
can you stop talking to somebody while you on my record, please? And you still not sitting up straight for me like I asked you to before we got on court. I mean, before you went in the breakout room.
All right, Your Honor.
Yes.
Okay, they set a pretrial date of July 14th at 8:30 a.m.
All right, so the court is going to set the matter, adjourn the pretrial conference to, I apologize, what's that date again?
July 14th.
To July 14th at 8:30. I'm also transferring the case to the domestic violence docket by the Honorable Austin Garrett. The court will note that the complaining witness is present. And therefore, Mr. Henderson, while you may appear, you're not required to appear. We will note the file that you appeared today. And then Ms. Robinson, well, Miss Stevenson, is this the case? I know you all asked me on a case, I don't know if this is it, to reduce the bond or to take away the tether, and I didn't because it was a potential DV case. That's not this. Ms. Robinson is being held on something else other than this case.
So I'm actually, I probably need my partner, and if Mr. Murad talked to Ms. Robinson this morning, because I am puzzled as to why Ms. Robinson is incarcerated right now.
Okay, well, let me bring Mr. Murad in.
If I may, Your Honor.
You may.
So, Judge, on June 15th, we actually had a tether violation hearing for Ms. Robinson. I don't know if the court remembers, but this is the case where Ms. Robinson put the aluminum foil on her tether.
Oh, yeah. Okay, I knew it was something. Okay, and then I said I wasn't, but I didn't. Oh, and then so did I not give her? I didn't give her a personal bond either, did I?
I have bond condition amended to $1,000, 10% with GPS tether and house arrest.
Okay. All right, Mr. Murad, we figured it out. That's why I brought you out, but.
My apologies, Your Honor.
That's okay. Okay, so Mr. Murad, did you want to put your appearance on the record then for this one, or?
If I may, Judge, yes, Ryan Murad, P3665 on behalf of Ms. Darlene Robinson.
All right, so I'm transferring the case to Judge Garrett. There's a pretrial conference for July 14th. Mr. Henderson, if you want to appear for that pretrial conference, like I said, you may, but why don't you unmute and tell me, how did you log into this court today? How did you log in? Did you use the Zoom ID number or did you click my name? Unmute and tell me.
ID number.
Okay, so if you log in to Judge Garrett on the 14th, his Zoom ID number is identical to mine, except instead of where you see an 8, you're gonna make it, I'm sorry, where you see a 9 in mine, you would make it an 8. So his is 338, mine is 339, those middle numbers. So you just change that 8, I'm sorry, I keep saying it backwards. You just change that 9 to an 8 to log in.
Yes, ma'am.
Okay, with respect to Ms. Robinson, I did say that if she didn't bond out, I would readdress her bond today. Mr. Murad.
Your Honor, with regard to that, unfortunately, Ms. Robinson has not been able to post the monetary bond. She has sat in the Wayne County Jail for well over a week because of this violation. Judge, I'd ask the court to consider amending her bond to personal. I know the court's not inclined to remove the tether today, but I would ask the court to consider it. If not, Judge, we are asking for at least the bond to be amended to personal bond. She spent I believe, over 10 days in the Wayne County Jail.
All right. So any response from the people?
So, Judge, I had an opportunity to speak with Mr. Henderson about this case. And from my understanding, Your Honor, Ms. Robinson is still reaching out to Mr. Henderson via phone. She's actually allegedly calling Mr. Henderson from the jail numerous of times. I know that prior to her being incarcerated for the tether violation, when she was out on the GPS tether, she was sending cabs to Mr. Henderson's home. She was also sending cabs to people he knows. She was reaching out to Mr. Henderson's children's mother and those type of effects, Your Honor. So I'm actually going to ask the court, based on that information, to keep the bond as is and keep the GPS tether with house arrest in this matter, due to the information received from the people, Judge.
Your Honor, may we be heard as to that as well?
Yeah, but who gonna talk? Because now you know y'all both can't keep talking on the record.
If we both could, that would be helpful, because Mr. Mraz spoke with Ms. Robinson today, Your Honor. But so I think that both of us should represent her today.
I don't know how Ms. Ritter gonna feel about that, but go ahead.
Okay, I just really want to speak to the contact. I was confused as to why Ms. Robinson was still in jail today, because I have received numerous text messages from Ms. Robinson where she has expressed concern for her personal safety because of the complaining witness, directly and through third parties attempting to contact her, to the point where I responded to Ms. Robinson that if she was concerned for her personal safety because someone was harassing her, that she should contact the police. Again, I have messages that were sent to me via text message as well as email. So Ms. Robinson clearly understands that she should initiate no contact with this complaining witness, that she shouldn't have any contact with him through third parties, and she doesn't want him to contact her either, either directly or through third parties, Judge. I'm gonna join my brother counsel's motion for the removal of the GPS tether, Your Honor, at least to the reduction of the bond to personal with the GPS tether, because that actually would help to provide Ms. Robinson with a necessary defense if the complaining witness is alleging that she's coming over to where he is.
Well, here's the thing.
So she doesn't want to have contact with him. She's afraid of him
Yeah, they both,
and other people working at his behest.
Let me tell you what I surmise. I surmise they both want to have contact with each other. That's what I surmise. Now, one thing is for sure. If Ms. Robinson has called Mr. Henderson from the Wayne County Jail, where all phone calls are recorded, on a recorded, I don't need any affirmation. I don't need any thumbs up, thumbs down. I don't need anything.
Mr. Henderson, just listen, please.
Yes, ma'am.
If that has occurred, it's so easy to get. It's so easy to get. Like, it's so completely easy to get. What I also know is that Ms. Robinson goes through a lot of stuff to get around stuff that she want to get around, because she put that aluminum foil on that tether. She left out that house when she wasn't supposed to. She's getting into it with a person who she is dependent on because she is tethered to their home. And like I said at the bond hearing, I wouldn't get in the argument with a person who I had to be tethered to their house. I wouldn't get in an argument with them. They could say whatever they want to say to me, and I would just try to sit there and try to take it long as they weren't hitting me or cursing me, belittling me. And then if I had to get away from them, I just go on the porch. I'm not gonna leave the house or I go in the backyard. So listen, I never understand these types of situations. I never do, but because if somebody don't want me, I don't want them. If they don't want me, I don't want them. And so I'm not running after you begging for you to do nothing. And then I'm not, yeah. So I never understand these type of situations. What I'm saying is, I don't know who's contacting who, but please don't be silly enough to think that it's not easy to find out who's contacted who. With the flick of a pen, we can get the record just with the signing of a warrant, with the signing of a subpoena. We can get the records. So stop acting like we can't tell who contacted who. Stop acting like if somebody, a third party contacting another person, we can't get the record and say, you called this person on this day, this person called her on this day. Stop acting like kids on here. Let's act like some adults. If the relationship is over, it's over. Move on. Move on to the next thing, to the next person, to the next whatever, to get on somebody else's nerves. Go get on somebody else's nerves. But I'm gonna tell you this. If either one of you violate this no contact provision between now and July 14th, I am going to lock you up. If either one of you violate this no contact provision before the matter reaches Judge Garrett, I am going to lock you up. If you put something on Facebook, I'm locking you up. If you send a message through Messenger, I'm locking you up. If you send a text message, if you make a phone call, if you send a taxi, if you send your friends, your homeboy, your homegirl, I'm locking you up. Miss Robinson, if you contact him, I'm revoking the bond, the whole bond. And you're just going to be remanded to the Wayne County Jail until the case is heard. Now, wouldn't that be a shame to be remanded on a case and spend more time in jail waiting on the case to come to trial than you would be once if you get convicted? Then you get convicted, they just gonna say credit for time served because you've been serving the time. And then God forbid you get acquitted and you've been sitting in jail.
Can I say something?
No, you cannot.
No.
So let me say this. I don't know who the culprit is, but you better stop it. You better stop it because you're being silly. You're being ridiculous. The case is in court now. Let it be in court. If you wanted to be together, you should have stayed together. Let it be in court. So nobody is contacting anybody. There is nothing going on in the world that needs to be discussed between Darlenia Robinson and Dietrich Henderson. If they announce we getting ready to go to war, you two can't discuss it. The court is going to reduce the bond to a personal bond, but I am going to, don't shake your head at me. If you want to do my job, go to law school, get a law degree, practice for 5 years, and then run for judge. Put your cup down because we're in court and there's only 4 people on the screen that are permitted to drink anything because we're doing all the talking. So if you think you can do the job better than me, please apply for it. Because I could just let her go without a tether. That's what I could do. And if you keep talking, that's what I'm going to do.
Mr. Henderson, please stop talking.
Well, let me say this, because his behavior right now, like that whole head back, lean back, whatever, is all disrespectful. And it's all inappropriate court behavior. All of it is. All of it is. All of it is. I am going to reduce the bond to a personal bond. I am not going to amend the tether. It will remain. It will remain a tether. She will be tethered to somebody's house who's going to allow her to be tethered there. And then it will also still be a house arrest tether. And then I want Ms. Ritter to confirm from somebody the allegation that she has been calling from the Wayne County Jail. Because I want Judge Garrett to be aware if she has been calling from the Wayne County Jail, so that on July 14th, when there's another motion made for the adjustment of the tether condition, they can be aware as to whether she in fact was calling from the Wayne County Jail. Is there anything else with respect to Ms. Robinson from the lawyers? From the lawyers?
Nothing on behalf of the people, Judge. I will inquire on getting the transfers for those jail calls.
Nothing further, Your Honor.
All right. Then Ms. Robinson, when they have a tether available, they will let you out of jail, but you are on house arrest. Now, let me say this, put some more aluminum foil on a tether. I double dog dare you. I double dog dare you to put some more aluminum foil on a tether. And I'm gonna remand you again. I'm gonna remand you. I'm gonna remand, if you tamper with that tether, I'm gonna remand you to the Wayne County Jail. Anything further?
No, thank you.
I'm giving out legal advice. 36 District Court didn't issue a ticket. Now the police officer issued you a ticket. And if it's your fault that you didn't pay the $45 reinstatement fee, that's your fault. That's on you. I don't have anything to do with that. When this case first came up, the Secretary of State suspended your license. So tell you go back to the person at the Secretary of State, tell them Judge Bryant said stop giving out legal advice because they don't know what they're talking about. That's number one. Number two, we can't remove nothing from the Secretary of State. That's a state agency. They have requirements and rules. If you don't pay your fees, you can't get your license. They don't have nothing to do with me. In fact, there is a strict rule from the state of Michigan Secretary of State that we cannot even waive the fee. So the person who's telling you that don't know what they're talking about. But let me tell you who know what she's talking about. Me. I've been doing this. Was placed on probation for 12 months back in October. This is his halfway point, but he's not near ready for discharge, Ms. Stevenson. And he tested positive for alcohol in May. And this is his second go round with the probation. He's failed to report in April. He failed to report in April and July. It's not looking good. Ms. Stevenson?
Your Honor, I would agree with that, and so would Mr. Norman. And having had the opportunity to have a kind of frank discussion, he does understand that his freedom at this point is hanging in the balance. We do want to draw the court's attention to those 2 conditions that Mr. Norman has complied with, Your Honor, in addition to coming to court as he's ordered to do. So he does have some work to do. He does have some time to do it, and he does want to do it instead of going to jail. So I'm asking the court to give Mr. Norman the opportunity to continue to move toward compliance, Your Honor.
This is his second chance. This is at least his second chance. Because they saying back in 2020, he started treatment. This is 2023. This is 2023. So we're not going past October 2023. We're not going past 2023. If Mr. Norman doesn't want to do the probation, we can just do the alternative to the probation. If Mr. Norman fails to report to his probation officer, I'm revoking his probation. As a condition of probation, Mr. Norman, you are to report to probation on a monthly basis. On a monthly basis. On a monthly basis. You are not to consume anything containing alcohol. It looks like I converted fine costs and fees except $260 to community service, and you've only completed 17 hours. This is a lot to do. Probation is a lot to do. And the only benefit to the probation is that it keeps you out of jail. I won't say the only benefit because service is the rent we pay for the space we occupy. Everybody should be doing community service. But one of the benefits is that it keeps you out of jail. But if you don't want to do the probation, we're going to go to the alternative to probation. I'm going to set this matter for another review. This is July. That was October. I mean, Ms. Stevenson, he only has 3 months. Let's be realistic.
Yes, Your Honor. I just I didn't want to ask to
3
to
months
push it.
to complete 97 hours of community service, to report every time he's ordered to do so to his probation officer, to do the alcohol highway safety, to do outpatient treatment and view the consequences video. He hasn't done that in 9 months, and we think he's going to do it in 3.
Honestly, I don't, but I do think that rather than asking the court to give me as much time as Mr. Norman needs to fully comply, at least if we get to that October date, I think he would be able to demonstrate to the court that he's ready to do what he needs to do to get this done.
All right. I don't believe it. Mr. Norman, well, you had your hand up.
Yes, Your Honor. I'm just having a very hard time, Your Honor. I work the night shift. When I get off at 6 in the morning, I get off at 5 in the morning. The bus doesn't come until 7. And then I have to be to probation by 8. I can't make it. I have to get home to take my child to daycare, and I have to try to get the little rest I can to get back to work. I'm just asking if there's any way you can help me so I get my license. I went to the Secretary of State. I have a vehicle. If I can get my license, it would be much easier for me. Trying to get around with an Uber and the bus routes, the way they run, I just cannot. I cannot, and that's been the holdup. I've been trying
That's not the holdup. The holdup has been that you did nothing from 2020 to 2022. That was the first holdup. The second holdup is I don't have anything to do with you getting your license. And now that you've fiddled around and waited too long, but certainly if he can't do the few conditions I'm giving him on this doc, he definitely wasn't going to do the conditions in sobriety court in order to get a restricted license. So I'm not the Secretary of State, and I can't give you, I don't have anything to do with the licensing. The fact that you don't have a license, I don't know why you don't have a license. It looked like the license on this case would have been suspended back in 2020. So I don't know why you don't have a license. You need to ask the Secretary of State why you don't have a license.
Can I speak, Your
No,
Honor?
you get ready to, yeah, you get ready to try to tell me what somebody else said. Go ahead.
I'm sorry. I went to Secretary of State. They said the whoever issued the ticket, this is the only thing on my driving record. They said they have to remove it. So that would have to be 36 Court District, Your Honor. I don't know what else to do.
36 District Court didn't issue you a ticket. The person at the Secretary of State should stop giving out legal advice. 36 District Court didn't issue a ticket. Now the police officer issued you a ticket if they saying whoever issued the ticket. And if it's your fault that you didn't pay the $45 reinstatement fee, that's your fault. That's on you. I don't have anything to do with that. Your license probably got suspended when this thing first came up. When this case first came up, the Secretary of State suspended your license. So tell you go back to the person at the Secretary of State, tell them Judge Bryant said stop giving out legal advice because they don't know what they're talking about. That's number one. Number two, we can't remove nothing from the Secretary of State. That's a state agency. They have requirements and rules. If you don't pay your fees, you can't get your license. They don't have nothing to do with me. In fact, there is a strict rule from the state of Michigan Secretary of State that we cannot even waive the fee. So the person who's telling you that don't know what they're talking about. But let me tell you who know what she's talking about. Me. I've been doing this for a long time. And so you need to go to the window and pay your fees. And then when you pay your fees, it can be lifted from 36 District Court. The Secretary of State, as I indicated already, are the only people who, if they choose to, based upon whatever rules they have, can issue you a temporary license, a restricted license, or whatever other kind of licenses they issue from the Secretary of State. They didn't teach no class in law school about licenses. They didn't give me any authority about licenses. And the only judge that I know of in this court that can ask for a request or do whatever they got going on with those restricted licenses are the sobriety court judge and people in the sobriety court. Otherwise, that's between you and the Secretary of State. So as I said before, these are the requirements that have to be done. Now, maybe your lawyer, I don't know if they advise on traffic things, but I don't do traffic cases and I don't know the traffic laws like I used to when I was doing traffic cases. What I know is that I have nothing to do with the fact that your license is suspended. What I know is that we didn't issue you a ticket. What I know is that the prosecutor's office issued a complaint against you for drinking and driving. So, and what I know is that the prosecutor's office has nothing to do with reinstating licenses. So that sounds like somebody at the Secretary of State don't know what they're talking about. Nonetheless, you could pay your $260. Miss Sealman does the $260 include, because his fees for me should only be $210 if I did what I normally do. Nonetheless, the $260, does that include his reinstatement fee to the Secretary of State?
Let's check. Let's see here. It's on here, so yes, I do.
Yeah. So what they should have told you is pay your money, pay your reinstatement fee, and then you can get your case reinstated. I mean, you can get your license reinstated.
Excuse me, Your Honor.
Yes, go ahead.
So I actually did make a payment of $300. Do you guys see that?
When?
That was last month. I came down to 36 for, not last month, the last time I seen Mr. Bradfield. So last month sometime. And I came down there, I tested, and I paid 300 at the window.
Miss Ritter? I mean, not Miss Ritter.
He's correct, Your Honor. June 12th.
So why didn't his balance go to zero then? Does he have other cases at the 36th District Court?
He has a balance of $260.
Right, but why? I converted 97 hours to community service. Why would he have a $260 balance if he paid $300? What was his amount? And he's only on a 12-month probation. That math ain't, that's not mathing up.
Yeah, they got it on here, but I don't think they wrote it in the body of the register of action, but I don't believe they actually took it off. So that's probably why.
When you say they wrote it in the body, you talking about the community service conversion?
Right, they wrote it on here. I see it. It says convert $970 of the balance to $97 of community service, but they didn't go inside and actually take the money out.
Can you take the money out?
Yeah, let me. I'll print it out.
So $45 of that money goes to the Secretary of State, and they should be able to give you a license.
Thank you, Your Honor.
And tell them, you gonna go back to the same person. He like, Judge, I'm gonna just stand in line, and when they call me up there, that's who I'm going to. I'm not asking for the person. No, I know. All right. So now that you can go get your license, if this is the only thing that you have, like they said, and now we're gonna send them their $45, and they are gonna reinstate your license, right? Are you gonna finish this probation so I don't have to put you in jail, and then you can't take your kids to daycare and all of that stuff?
Yes, Your Honor, and all my intent to get this over with.
Okay, and then stop drinking.
Yes, Your Honor.
Okay. All right, I'm glad we had this talk, Mr. Norman. Let's continue you to the final review, but I need you to pick it up. I need you to pick it up. October 26th. October 26th, the clerk is changing the information. And so the money that you paid, it will go towards your reinstatement fee to the Secretary of State. And they will reinstate your license, okay?
One more question, Your Honor.
Yes.
I do appreciate you helping with the community service, but being that I put 300, is it still 97 hours I have to complete, or?
No, it'll go down by 4 hours. Let's see. You paid 300. How much did you pay?
300, Your Honor.
So the 210 was the mandatory cost. So that's $80 left, right?
Yes, Your Honor.
It'll go down by 8 hours. So now you have to do 89 hours. And then here's the thing. So Mr. Norman, because I don't want to put you in jail. I promise you I don't like it. If you need less community service, if when you get your license back, that help you go to work easier, and that even though the gas is high, that might be more expensive than riding a bus. If you are able to pay some of the money, then I will strongly consider, as long as you have stepped up your game, I will strongly consider playing ping pong. What do I mean by that? Turning the community service, some of the community service back into money. If you feel like you could pay versus, but you have to have completed. Only way I'll consider that, you have to have completed the alcohol safety. You have to have either gotten back in treatment or gotten a letter from the people saying you don't need treatment. You've already paid your court balance. And so I'm going to make a note. So you at least have, oh, and you have had to view the consequences video. So if you've done those things, I'll consider, if you want to let you pay instead of finish the community service, okay?
Thank you, Your Honor.
You're welcome. But I'm writing a note because I'll swear that I didn't say it. So let me write this note.
This video and all.
Well, that's it for today, ladies and gentlemen. If you like this court content and you're not a subscriber to this channel, please do me a favor and subscribe to this channel and help this channel grow. So that's it for today. Tomorrow is Judge... Let's see. Tomorrow is Judge West, Judge Raquel West. So I will see you guys tomorrow at 3:00 p.m. Central Time, 4 o'clock Eastern Time for Judge Raquel West docket. You all have a wonderful evening. Ta-ta and ciao, ciao, and I will see you guys tomorrow on the next one.